invariably interpret it as suspicious behavior and railroad you from the word go. I would ask what the officer has stopped you for. He then has to justify the contact. If it's simply a matter of asking whether or not you may have witnessed anything unusual or suspicious in the area, you may choose to assist or not, if you can. You have the right to walk away at this stage. You're not under any obligation to speak to the officer. I would ask, am I being detained? And if the officer says no, I would then ask him if I'm free to go. He has to say yes or no. If yes, I'd thank him and leave. However, if he says no, my next question would be, what is the reason for the detention? Again, he's obliged to give you a reason, and he can detain you for up to 45 minutes without arresting you, in order to determine whether or not he's justified in his suspicion of you. If he doesn't give you a reason, I would insist on leaving, and I would actually attempt to leave. This will either call his bluff, in which case he'll not try to stop you, or he'll be forced to arrest you, in which case he'd better have a good reason. An unlawful arrest would be just cause for a commercial lien, if you know how to execute one. Please take the time to watch my Dealing with the Police and Dealing with the Police Addendum broadcasts on YouTube for a better presentation of these procedures. But all I'll say for now is that the golden rule on arrest is to say the following. Officer, for and on the record, there'll be no need for force or violence. I will not resist arrest. However, you are obliged to note that I'll be operating under protest and duress every step of the way. I reserve all of my rights at all times and waive none of my rights at any time for any cause or reason. I do not consent to this arrest. I do not consent to the taking of DNA or blood samples or fingerprints, and I do not consent to being placed on any database. Then, you keep your mouth shut. Once you get to the station, you repeat your mantra and sign nothing. Of course, they'll try all sorts of intimidating tactics to get you to sign or to give a statement. And it's this period that sorts the men from the boys, unfortunately. It can be pretty intense. Without just cause for the arrest, or without any input from you, they simply have to release you. It's just a matter of time.
Now I recommend that everybody downloads the podcast and goes back and plays that over again, and also go to YouTube and search How to Handle the Police by The Anti-Terrorist, because he gives some really, really good information. Now, what a lot of people don't know is that the police aren't supposed to just take you straight to jail. They're supposed to take you to a magistrate. A magistrate's job is to determine whether there was probable cause and if it should go to a district attorney, if charges can be filed. You don't thank the magistrate for anything that he's doing, and you challenge the magistrate. If he sets your bond, you say, well, where's the probable cause? Make them prove their case before you accept any kind of charges or anything like that. If you just say thank you and move on and try to go get bonded out, then you're just agreeing to everything that they're saying. Don't agree, don't submit, question everything is the point. Now, when you get to court, that's a completely different ball game, but we're still in the same ballpark. So the next question that we asked him was, how do we handle ourselves when we go to court?
I could regurgitate my standing in court video here, but I think it would be irresponsible of me to do so. In my experience, people are looking for a quick fix or a silver bullet, and there isn't one. After all, some people only need to hear the starter pistol and they're offered a sprint without having the right running shoes or tying their laces, and they invariably trip themselves up or run out of steam. A well-rounded education is required before playing in court, and I can only suggest going on a few law merchant seminars. Sam Kennedy, Winston Shrout, Jack Smith, Brandon Alexander Adams, reading a few law books, as boring as that can be, taking some online LSATs and so on. In terms of the interactions, the personalities involved, and the format in court, there's just no guarantee that a hearing is going to go the way we expect it to. A court hearing could go off in any number of directions depending on any number of catalysts, including the paperwork being filed, your attitude, your fear, your overconfidence, and so on. Court hearings should go fairly and honorably, but they don't in most cases. I no longer attend court, and I have no intention of doing so again unless I'm aggrieved enough to want to take someone into their private business venue for my remedy. If I'm accosted by a third party, and I'm invited to go to court, I simply return the paperwork as defective. As Robert Menard might have mentioned, the court needs the consent of both parties to be able to adjudicate, and I do not consent. You can learn about returning defective process by going to peoplesrights.com. That's www.peoples-rights.com. The trick that the courts use to get you to voluntarily subject yourself to their jurisdiction is by sending out or serving defective service, defective warrants, notices to appear, or similar official-sounding papers. Defective service simply means the due process of law is not being followed. They're all, in fact, just invitations. Now, defective service, which is usually associated with victimless crimes, becomes perfected when you answer to the defective service by replying as the fiction and/or voluntarily walking into their court, standing behind the bar, entering into the benefit of discussion with the court. Simply answering to the name is all it takes. However, if you want a little court experience, a good start would be my 3-part video on YouTube called Standing in Court, but I would definitely recommend looking at the other study resources before you even attempt to go in there. I don't recommend going into court with half an education. They'll eat you alive.
And those are some very wise words, which was the reason why I was speaking the way I was in the beginning of the broadcast. You don't want to go in here and try to use this process without fully understanding it. But you can take some of these tactics and apply them to the current system that you're forced to be under when you go to court. You can save yourself from giving up a lot of your information, and you can use these to empower yourself. And once you have a full education, then you can walk in here like a sovereign.
I totally agree. I think that if anybody goes into court and expects to be able to wiggle their way through it without doing their research about how to keep your sovereignty whenever you enter a courtroom, then you're going to be basically crucified. So it's really important that people do their research before they go into trying to manipulate the system.
One of the videos that I found real informative was his standing in court video. And again, you can go to YouTube and type in the anti-terrorist standing in court. And I think it's a 2- or 3-part video. He puts a lot of work into what he does. So I recommend everybody takes a look at that. But I asked him, what is the significance of standing in court? Because I wanted to hear it from his words. So here's how he answered that one.
The word standing, as I've used it in my broadcast, refers to your ability to hold your own in court. But it essentially refers to your claim. If the judge were to say, you have no standing in this court, he's presuming and assuming that you do not have a claim. And your claim in reality is that you are the creditor in all matters of commerce where your signature's been used. No standing also refers to your inability to represent yourself because you've made an in personam appearance. Your honor and status as a sovereign is effectively being called into question, but most people have no idea of this fact.
And this goes again to what I was talking about earlier, how people go in and grovel, how they say thank you when they're getting the fines and things like that. It's really sick how these people act in these courts and grovel to these people who are in a robe sitting on a bench. They have absolutely no power. Everybody's born equally. They use words as their power. But one thing that they try to do is try to gain jurisdiction over you with methods like all rise. When the judge walks in, the bailiff asks everybody to rise. Then you're following command. Now, what we're about to get into is a little more advanced, so the people who don't know anything about this philosophy may not get anything out of this or understand this. So I recommend that you go and watch the anti-terrorist videos. Go to his YouTube channel, The Anti-Terrorist, and watch every single one of his videos. But the question that I had is, how do you handle yourself when you walk in? Because the first thing that they're going to do is ask you to empty your pockets and go through a metal detector. As a matter of fact, in some courts, they even ask for your name before you even walk in the building. The best thing that I can think of is to keep referring to your legal fiction as a third person and basically say, I'm here representing the legal fiction known as, Chris Geo or whatever, and then proceed that way. So let's see what he had to say about the tricks that they use when you walk in the building, when you go through the metal detector, and the commands that they give you.
Now, this is a valid question, and another example of the tricks they use to gain jurisdiction, but again, you're going to be milked unless you're fully aware of all the pitfalls and how to deal with them. With a rounded education, you could quite easily gain entry and use your person to your advantage and for your protection. I would simply keep referring to the legal fiction as a third party, as you suggest, and make them prove their claim that I am the fiction. But having said that, unless you are the claimant, why attend court at all? Unless you're about to lose your home and you literally have nothing to lose by jumping in at the deep end, I recommend taking time to study before attacking your utility bills or your parking tickets. You can find a list of recommended study sources at the AT website. The bottom line is this: the lawyers, barristers, and judges representing our legislature and judicial system conspired to ensure that anyone who's accused of a so-called crime and posts bail signs a contract to appear and consents by that contract to everything that happens afterwards. Anyone who applies for a legal representative signs the same contract without knowing it. And anyone who privately hires a barrister or a lawyer to represent him in a court hearing consents to the same contract when the lawyer files a notice of appearance. When you hire legal representation, you sign a power of attorney. He's required to file his notice of appearance in that case, and that notice of appearance gives your consent and ties your appearance to the proceedings. Now, without any of these contracts, the court can't proceed against you. When that happens, the judge and the prosecutor attempt to trick you and intimidate you into giving your consent, of course. But if you know how to take what they throw at you and stand your ground, they'll be forced to concede, and they'll either adjourn in order to regroup, or they'll drop the case entirely.
Not really, except that basically if they can't gain jurisdiction over you by getting you to obey their commands like a dog, then they have to either adjourn